Good morning, everyone, and thank you for joining us in Johnson Jackson for giving the shot in the arm what hospitality employers need to know about the COVID vaccine. Before we get started this morning, I do want to remind everyone that this webinar is going to be recorded and will be posted on the FRLA webinar page and FRLA YouTube page. It will also be emailed out to all attendees after the webinar. Real quick, we just have to read a quick disclaimer since we are giving some advice this morning. The information provided here is the educational purposes, and the FRLA does not warrant or endorse any particular provider. FRLA is prohibited from providing specific legal, financial, or accounting advice, and the information represented here is not intended as such. FRLA encourages businesses to consult qualified, competent advisors in these fields to explore their specific situation. This webinar is being recorded for future use by the association and other industry members. Your participation in the call is deemed to be your consent to the recording. And if you would like to ask questions, please ask them in the control panel and we'll address those at the end of the webinar. So with that, I'd like to hand it to VP of Membership, Dan Murphy.
Thank you, Ashley. It's my pleasure to introduce our two speakers this morning, Chris Johnson and Chris Bentley with Johnson Jackson Law Firm. I also want to send out a shout out for Johnson Jackson for helping us over during this pandemic. They have been so helpful to us and our members, and I just want to thank you, Chris and Chris, for helping us with this webinar and all the other ones involving PPP, employment law, and so forth. With that, I'd also like to, I'm going to turn it over to Chris, and Chris, it's all yours. Thank you, gentlemen.
Good morning, everyone. My name is Chris Bentley, and with me is Chris Johnson. We are both partners at the law firm of Johnson Jackson, PLLC. At Johnson Jackson, we specialize in management side, labor and employment law, and we have represented and advised numerous restaurants and hotels in various labor and employee disputes. Today, we're going to discuss some of the challenges that employers will face as COVID-19 vaccinations continue to be rolled out throughout the country. While some of these considerations, might seem a little premature, since the vaccine rollout has continually been limited to healthcare workers or people over the age of 65, it really will only be a matter of time when more and more individuals will be eligible to or be able to receive the vaccine, including those individuals that make up your respective workforces. So although this rollout, throughout this rollout, you as the employer will have to face new considerations. You will have to start thinking about, should you mandate all workers to receive the vaccine? What laws, if any, protect those employees who decide to not get that vaccine? And how should the employer address those situations, especially if the employee is objecting based on medical or religious grounds? And can you provide those employees with any type of reasonable accommodations? As you will see from our presentation, there's unfortunately not one answer that really fits all here. You also see that the guidance here is ever changing, and we've seen this throughout this pandemic, that the EEOC or other agencies, the Department of Labor or CDC, has constantly revised its regulations. So we have to therefore anticipate where we think they're going to go or where the courts are going to go when we start implementing or deciding to implement, mandatory vaccination programs. So, since the beginning of this pandemic, employers have been concerned with the Americans with Disabilities Act. And if you haven't been, well, then I can tell you that your attorneys have definitely been worried on your behalf. And they were worried about, the limitation on medical examinations or inquiries as it relates to this pandemic. The ADA here, it provides that employers may not require a medical examination or make medical inquiries unless such an examination or inquiry is shown to be job related and consistent with business necessity. So the question then becomes, what does it really mean to be job related and consistent with business necessity? Well, an employer can meet that standard when an employee has a reasonable belief based on objective evidence that the employee's ability to perform essential job functions will be impaired by a medical condition, or an employee will pose a direct threat due to medical condition. The next slide, if you could, Chris. So in other words, employees need to make sure that the company has a business reason for asking the question. The employer cannot merely pry into employees' medical history. It really needs to be a job-related reason for that inquiry. And this is why most employers and their lawyers were worried at the outset of this pandemic about asking certain questions that might expose themselves to the potential ADA violations. I mean, it was just 9 or 10 months ago that employers were asking if they could ask employees, are they experiencing COVID-like symptoms? Can we take employees at temperature, et cetera, and et cetera? And these were all very valid questions. But luckily for us in March, the EEOC was able to answer those questions, which allowed the employers to take those actions. So now here we are again, and we have a host of all these new questions, and that all surrounds what about the vaccine and whether or not we can make it mandatory or whether or not we can encourage it. Okay.
Hey, Chris.
Yes.
This is Dan Murphy. Chris Johnson, you might have your volume up. There's a little background feed on there. Chris, so if you'll mute I think your volume's coming out over Chris while Chris is talking, so you have to mute until you're ready to speak. Let's see if that works. I think it's not just me. There's some background noise there. Apologize, guys.
No worry. Thank you for letting us know. And so just this past, in March, they were able to answer those questions. Well, now we have new questions arising, okay? And it's all about the vaccine. So now here we are, and it was just this a month ago, December 16th, the EEOC answered this question when it updated its guidance. Now, in the guidance, the EEOC confirmed that employers may administer a vaccine, mandate that a vaccine be administered without running afoul of the ADA. The EEOC made it clear that understanding a vaccine is not a medical examination or inquiry, because simply administering a vaccine, an employer is not seeking any information that it might elicit information about an employee's disability. Therefore, an employee can ask employers for proof that he or she has been administered a vaccine. In fact, I'm sure a lot of you have already seen this from people maybe on Facebook. A lot of healthcare workers or other people that have been eligible to receive that have posted pictures of the vaccination card. And when you look at that vaccination card, you see the person's name, you see when that vaccination was administered, and the date. But nothing on that card and tells the employer or anyone else if they have any underlying medical issues, if they have any type of disability. And that's all fair game. But that might change, however. You were thinking, how will that change if someone does not get the vaccine or declines to take the vaccine? Well, if that happens, we might have a situation, for example, where Chris Johnson here, goes to get I tell him to go get the vaccine because it's mandatory. He declines to do so. Then my very next question is, why? Why, Chris Johnson, did you not get the vaccine? He then could be forced to tell me about his underlying health condition. And now, since you made this medical health inquiry, you are now subject to the ADA standard that requires you to show the question, was it job related and consistent with business necessity? Okay, so the key here is not to ask the question unless they volunteer the reason for not taking the examination. You have a policy, and the onus then is on you to raise why he or she decided to not get the vaccine. And based on that response, you then will have to take the analysis a little further, and that's what Chris Johnson's about to get into.
So as Chris was discussing, the pre-screening vaccination questions can implicate the ADA's provisions on disability-related inquiries. And as he hinted to, if you get into that and you cross that line, then you can raise ADA discrimination claims inherently if an adverse action is taken later on down the road. So the interesting part and where this overlaps with the vaccine is the CDC's recommendations are to ask a certain set of pre-screening questions before administering the vaccine. And those pre-screening questions are set to try to protect the potential vaccinated from some sort of medical side effect. Obviously, certain people with certain medical conditions are probably at a higher risk of adverse side effects from receiving the vaccine. But inherently, those pre-screening questions are disability-related inquiries, right? So that leaves employers in a really sticky situation. Okay, so the CDC is saying, before I vaccinate someone, I can't ask disability-related questions, or excuse me, the ADA is saying that, but the CDC is saying you need to ask these questions to protect your people. So then the necessary question goes, well, how do I accomplish both of those goals? And they have set up 2 exceptions to that general rule. So if the employer's vaccination program is voluntary, and by that they mean exclusively, like specifically voluntary, both the decision to get vaccinated and the decision to answer the pre-screening questions must be voluntary. If those are both voluntary, then you can get around the disability-related inquiry problem. But if the employee refuses, excuse me, if the employer declines to answer the questions, you may, as the employer, refuse the vaccination, but you may not retaliate against the employee for not answering the questions and not getting vaccinated because the program is voluntary. The other way to do it is to not be directly involved in the pre-screening questions. So if the employer were to mandate vaccination and were to either be a healthcare provider that could vaccinate their own employees directly, or would contract with a third-party health provider to administer the vaccine for them, then those questions that you ask might be deemed to have knowledge for the employer, right? So if you say, I'm going to contract a healthcare provider to come out to my job site and administer the vaccine, you're going to be deemed to have knowledge of any of those answers to those questions, according to the EEOC. But if you say, you need to get vaccinated, but I don't care where you go off site, go to CVS, go to wherever they're administering the vaccine, then those pre-screening questions that information is not going to get back to you. Obviously, we're speculating as to how this might operate. Currently, there's not enough vaccine to go around for younger people, which are very prevalent in our industry, and we don't know which providers will be offering them. But getting yourselves out of contractual relationships or administering it yourself is a way to get around that issue. And then necessarily you go, okay, so what happens with my people that don't want to get vaccinated? So just as an aside, if they don't want to get vaccinated because of some political or some other personal motivation, then if it's a mandatory policy, they're subject to termination, right? If they have a disability or religious basis for declining the vaccination, the guidance requires us to go through what's called direct threat analysis to determine whether or not that person poses a direct threat to him or herself or others by not getting vaccinated, and then going through a reasonable accommodation analysis. Most of you probably heard of both of those things, but the way they tie together in this vaccination realm is very interesting. You cannot terminate an employee who refuses to get a vaccine for disability or religious-based reasons unless you're able to go through this analysis, right? So what is the analysis? So a direct threat, you have to conduct an individualized assessment, which means it's specifically not a one-size-fits-all. Each case is different, each employee is different. What you have to consider is the duration of the risk, the nature and severity of potential harm, the likelihood of potential harm will occur, and the imminence of the potential harm. Now that's a bunch of legalese, and it's something that looks like it'd be good to write down, but the reality of it is you have to prove that something bad's gonna happen, and it's likely to happen, right? And I will tell you that this is a tough standard in general. I've had a case in the restaurant industry with an employee with a seizure condition, and the concern was when they're running food that they would have a seizure unknown, that they would drop a tray of hot soup or something on a child or a table and injure somebody or themselves. They could fall on a knife, they could fall on an oven in the kitchen or a grill in the kitchen, and that was a close call. So the concern and kind of what the CDC is hinting at is that the direct threat may be tough to establish since most of us have been up and operating for the last several months without the vaccine. The EEOC's even hinted that a number of vaccinated individuals in a particular work site might be considered in the direct threat analysis, meaning if 70% of your workforce is already vaccinated or 85% of your workforce or 90 is vaccinated, that may factor into the direct threat. So the overall summary of this is it's going to be difficult, most likely, to prove direct threat. And even if you're successful in proving direct threat, you can't just immediately exclude that person from the work site or terminate them. You have to find out, is there a way I can accommodate that risk, right? So you say the unvaccinated person is a direct threat. They might pass the virus to myself or might pass the virus to a customer or to another employee that might lead to death. So you get there somehow on direct threat. Now you have to figure out, is there a way to accommodate that person? And in the service industry, obviously the work from home option isn't usually available, but wearing a mask might be, and that might be enough because that's what we've been using for a while. And if you haven't had a big outbreak in your work site during this pandemic, then there's an argument to be made that that might be an accommodation that lets them perform the functions of their job safely. Again, this is a case-by-case determination, but it's really important that your management team is really well versed in recognizing accommodation requests, because it is on the employee to let you know if they need an accommodation. Obviously, we just sat back and warned you about asking why you weren't vaccinated. And if the employee comes to you and you ask the employee, were you vaccinated? And they say no, asking why may be a violation of the disability-related inquiry. So under your policy, you can take adverse action. And then it's up to them to let you know, I need an accommodation for my disability. And then you have to start that process. So the important fact is the employee may not always say, I request a reasonable accommodation under the ADA, right? They may say something much more vague. They may kind of beat around the bush, and the law does put a little bit of a burden on the employer to recognize accommodation requests when they're made. They do not require them to say any specific magic words to get there. So making sure your team's trained up and recognizing that will be important. Just like the disability-related inquiry, I think less likely, but still prevalent would be the religious exception. Under Title VII, there's a sincerely held religious belief standard that allows people to opt out of something like this. The analysis is similar to the ADA in addressing the religious discriminations. Some standards are different, but each situation, just like the disability, requires its own discussion and likely discussion with counsel to figure out whether or not this is a sincerely held religious belief and whether or not those people pose a direct threat and whether or not there's any reasonable accommodation that we can provide. And obviously this analysis would be different for your people operating with direct customer service versus your high-level management personnel that might be traveling, but it might not have as much face time with customers versus your office staff, right? So all of this analysis is different, not only per person, but per job. And also you may have some pregnant employees that might push back on getting the vaccine. The CDC has acknowledged that while the changes for severe health effects are low for pregnant employees, they do have an increased risk of severe illness. The important part about this, and this is all speculation at the time, courts have not ruled on this, but the important part is you have to treat employees that are pregnant the same as employees that are not pregnant. And because this is so medical in nature, and because the Pregnancy Discrimination Act is a very hot topic and has been for the last couple of years, you will likely need to accommodate pregnant employees in the same manner that you accommodate disabled employees. If you have that issue, it's important to discuss, but I think that's the key takeaway, is treating them the same and not making, in this entire protocol, treating everybody the same is important. And then with these caveat exceptions that you have to analyze on a case-by-case basis.
So just kind of a recap of what we just so far have talked about in the first like 15 minutes is, if the employer, if you guys feel that there is a potential direct threat from exposure of COVID to not only your customers and your employees, and you decide then to roll out a mandatory vaccination policy, you are able to do that. The guidance has allowed you to do that. However, you need to make sure that there are exceptions to accommodate anyone, and Chris, can you mute your thing for me? To accommodate anyone that has a disability and or a religious need that disallows that individual from getting the vaccination. And if they do so, then you have to also go through that analysis, what Chris talked about, the interactive process, and see whether or not there's a reasonable accommodation that can be provided to this employee. So knowing that, if you decide to have a mandatory policy, okay, and you have someone that did not meet one of those two exemptions, what do you do as an employer? So the question becomes, do you want to put yourself in a situation where you're going to take some type of disciplinary action, meaning in this case termination, and not allow that employee to work because they are not, he or she is not vaccinated? Well, there were some recent polls in December, just this past December, that showed between 27% and 40% of Americans indicated that they do not want to have to take the vaccine. And we've heard all different types of issues that come about the reasoning, maybe why they don't want it. Some of them are, the development of the vaccines were rushed. We don't have enough evidence to show that they are safe and that these can maybe lead to some severe side effects. Or there just might be a general distrust of vaccines, and something that has happened over the years, that some people just do not believe in them. And like I said, the doubts of effectiveness. So these are all valid concerns that employees, might raise. But none of those reasons that I just talked about are protected. Okay, that's just their concern. So you, as the employer, would then have the right to terminate those employees simply because they don't feel that they feel the vaccine was rushed, or maybe because of some type of political affiliation, they disagree with the vaccine, or whatever the reason may be. But those are insufficient. So the question then becomes, do you want to terminate? Now, a lot of employers have to really think about this, because if you decide to take that approach and you have a workforce that may be comprised, maybe 20%, let's say, of these individuals refuse to take it, not because of religious, not because of disability, are you willing to terminate 20% of your workforce? And if you do that, are you going to be severely short-staffed? And how are you going to manage that time while you look for replacements? Those are all questions, or fair questions, and some things that you need to consider. But what I can say, though, which the law will come down on you if you don't do it correctly, is you need to be consistent. So if I have Chris Johnson, maybe he's a stellar employee, and he's one I don't want to lose, but he says he's not going to take the vaccine. Well, I just make an arbitrary exception for Chris Johnson so he can continue to work in my restaurant or my hotel. Well, if I don't give that same benefit to another individual who maybe be a different race or a different gender or whatnot, then before you know it, they will be able to come back at you and say that you unlawfully discriminated against them based on a race, gender, age, or whatever it may be. So consistency is key, and you definitely have to think about how you're going to handle it if certain employees decide they are not going to get vaccinated. So one thing, some employers have already been talking about this, and what, different ways maybe around this is, what are their options besides termination? Okay, how can I try to get this workforce to get vaccinated? And one of the options is, as Chris already mentioned, was make it voluntary. Okay, make the decision, make it voluntary for your employees to get vaccinated, but strongly encourage it. And what are the options that we can strongly encourage it? Some people are talking about participation awards. I forget the employer, but I know one restaurant was actually offering gift cards. Their decision is going to offer gift cards to employees that go out and get the vaccine as almost like an incentive. Others are really going to educate their workforce. And I think education is a really important thing. I think the employer, if they take the time, maybe during a meeting or two, to talk to them about the benefits of a vaccine, and tell them and tell employees how they can address some of the fears they have, and also talk about how it would help the business that they're working for, and to try, attract other customers to come in there. You might be able to change the minds of some individuals, especially if we can talk about, well, there hasn't been much side effects or whatnot. I think that's all very important stuff to discuss with your workforce to make them feel at ease and show them the reason why they should go get vaccinated. Other considerations are paying the time for employees to go get vaccinated. So the time, maybe they do it it's a voluntary program, but they're going on their off day to go get vaccinated. Well, maybe we can go ahead and pay them for some compensable time for doing that. That might further incentivize employees to do it. Another is to offer PTO should the employee experience any type of side effects. There are some studies that come out that a few people do, and they might be, out of commission for a day or two. Well, if you allow them to use their PTO, that might be another incentive. And lastly is maybe provide them additional PTO. Because if you're requiring the employee to use his PTO for while he's out, well, then he is already exhausting what he already had and would be less incentivized to go ahead and get the vaccine. So maybe give them an extra 2 days should they need to. These are all options that employers are able to consider when rolling out a program that fits his or her or fit their company's desires, okay? The next thing we got to talk about, and we did talk about inquiries that employers would have, that relate to medical things. But one thing we haven't talked about today is GINA. And what is GINA? GINA is Title II of the Genetic Information Non-Discrimination Act, and it governs the disclosure or use of genetic information by employers. So it provides employers may not, so the law provides that employers may not use genetic information to make employment decisions or require disclose genetic information or require the employee to disclose genetic information. So what is genetic information? Well, genetic information is usually, disclosed about someone's family medical history. That's probably the most common. Or if they have been tested for certain, genetic different traits. Those are the two things that you usually see. And if an employee is disclosing, his family's medical history, and the employer knows that and ultimately takes an adverse action, well, that employee then can raise GINA, and try to suggest that the adverse action was based on the employer's knowledge of this genetic information. So like the other medical inquiries that we've discussed previously, we need to be very careful on what we're asking about when it comes to someone's family medical history. The next thing that we are going to talk about, which is going to be a hot topic, it will be OSHA, okay? And everyone is familiar with OSHA. At the present time, there is no OSHA standard that would mandate employers to offer COVID-19 vaccine. Nor at this time has OSHA provided us with any guidance. Now, amongst the legal community, many lawyers believe that OSHA may use its general duty clause to issue citations to employers that failed to offer COVID-19 vaccines. That could be a step they take. I don't think they will, but that's a step they could take. And if they do so, that would be under the general duty clause. So what is the general duty clause? It provides that employers must provide a place of employment free from recognized hazards that are causing or likely to cause death or serious physical harm to employees, okay? So without any specific guidance, how are we going to determine what OSHA is going to do? Well, one thing we can do is look at what we've done in the past. And in the past, back in 2009, we had that H1N1 influenza. And there OSHA looked at, how they were going to treat that. And they said, that employers could require employees to get the seasonal flu vaccine subject to certain exceptions. And those are the same exceptions that we've already talked about. OSHA, however, did not require on that for there to be a mandate for all employers, okay? You just need to look at it. And then this one, it was all about education and encouragement, okay? And that's OSHA. The next one is the National Labor Relations Act. I know most of you are saying is, why are we even talking about this? I do not have any unionized employees. But let's talk and say you do have some unionized employees. If the employer is deciding to implement some type of vaccination policy that which will affect a term and condition of employment, then the employer will need to bargain that subject with the union. And that is because it affects a term and condition of employment. That means it's a mandatory subject of bargaining, and you must meet with the union to discuss the rollout, discuss what you want to do, and come to an agreement, okay? But now, for those that do not have unionized employees, you still need to worry about the NLRA and its implications. Section 7 of the NLRA grants employees the right to engage in concerted activities for the purpose of mutual aid and protection. So this provision may protect the rights of employees who are engaging in concerted activities with regard to mandatory work vaccine. So where would we see this? How would this even come up? Well, oftentimes you might say, I, the employer, are going to implement a mandatory rollout of this vaccine. You all need to do it. Well, now on social media, on Facebook or whatnot, you might have a group of employees who are discussing or discouraging that other employees go and get this vaccine, and for all the reasons that we might have talked about. Well, if these employees are engaging in that step, if they are discussing this vaccine, well, it's a good chance that they are engaging in concerted activity. If the employer finds out that, oh my goodness, Chris and this other employee and a few other employees are talking about the rollout and discouraging people, and I'm going to fire them because they engage in this dialogue, which I saw on Facebook or some other forum, then their work is protected, and therefore you are going to be in violation of the NLRA if you retaliated against them for engaging in this concerted activity. Okay. The next thing we want to briefly touch upon is workers' compensation concerns. So if an employer has a mandatory vaccination policy, you know, there could be situations where you're going to have to notify your insurance carrier about a potential compensable injury. And you're probably saying, well, where would that occur? Well, it probably can occur in what I can think of maybe two things. One is if the employer gets some serious side effects that causes something. Well, maybe that might be a compensable injury because you were forced to get this, it occurred on the job, and therefore you have a compensable injury. The second, I think the biggest thing that I foresee where a workers' comp injury could be is if you require employees during the workday to drive to a facility to get the vaccination, and while they're driving to this facility, they get in a car wreck, okay? And now the question becomes, is that a compensable injury? And I think they would argue, well, that is in the course and scope of one's employment. The employee was following the directive that was being provided by the employer, which is furthering the business interest of that employer. And in that situation, as I was saying, it's very important to inform your carrier of what went down and so that they can protect you accordingly, okay? So I think those are some of the big concerns. So I know we talked for about 30 minutes right now, and I'm sure you all have a lot of questions about some of the areas that we got into. But just again, as a recap on where we're at, it's very important if you decide to go the direction of a mandatory vaccination policy that you have the exceptions that needs to apply. And if someone's unable to get that policy, that you engage in the interactive process to see if there's a reasonable accommodation that you can provide that employee. You also then need to consider all the other stuff we talked about to make sure that we're not taking any type of adverse action against these employees without really going through all the potential avenues that can expose yourself and your company to potential liability. So it's always important at those point in time, before you take that adverse action or before maybe you roll out this policy, that you do talk to your labor and employment attorney and really go through those. So because everything needs to be individualized, because like I said in the beginning of the presentation, unfortunately, there's not one answer that fits all for your organization.
Chris, I want to thank you, but do you have any questions? Please put them in the box up there, the Q&A, and Chris will be glad to answer them. We'll say that I did have a discussion with Zenith Insurance, who is our workman's comp provider. We will have a follow-up webinar with them in the next couple of weeks on how this is impacting workman's comp as well. Chris Bentley or Chris Johnson, what are 3 things that you would want to leave this group, piece of advice? Look, we're still kind of in a waiting period. What would you recommend them doing right now to prepare for this?
For me, and I'll let Chris piggyback on this after I start, but I think for me as an employer, you need to start thinking about this right now. You have to look at your organization and decide, where do you think you're going to go? We don't know when we're going to start seeing more and more vaccinations available, when we're going to be able to even have this really consideration. But it's important to start planning and constantly looking at new guidance that is being issued by either the EOC, the Department of Labor, or CDC, and always stay up front on that. And the reason why I think it's important to start planning is because you need to be able to know what direction you're going to take your workforce. You're going to need to be able to determine whether or not you believe that you are potentially exposing not only your employees, but potential customers, to this virus, and what protections you need to take. So I think that's for first and foremost. It's all about planning and being on top of it, because when you do roll it out, you want to be able to have those educational meetings with your employees and talk about it. Now, if I was the employer right now, based on the guidance that I know, I think the most important thing to do is probably have a voluntary vaccination policy, but strongly encourage it, maybe offer some type of incentives. Because if you do that, you avoid some of the pitfalls that happens when you have a mandatory policy. But again, each organization is different, and some might want to have a full rollout, so you can tell, so if customers come in, you can say, you know what, our staff is vaccinated. Now, the problem is You can't control customers or patrons that are visiting your restaurant or your hotel or whatever it is. So that's going to be another issue. But at least you can say your staff who is going to have close contact at least should have some protection as much as they can.
Yeah, and I would agree. I think the important thing is, the industry really is looking for a quick turnaround here. I know everybody's anxious to get back to the status quo, and I think while a lot of what we're talking about is speculative as to when this vaccine is going to be more widely available, this time is very precious to be ready. So when this becomes available, you can move on it. Having prepared already what you're going to tell your employees, what your policy is going to be, how you're going to handle exemptions, getting all of that taken care of now on an organizational level is key to being the first to get there. Because I have a feeling a lot in our industry are going to be utilizing the fact that their workforce is safer as part of their marketing utensil. So I think, and this is like we said, we keep saying it varies and it's company to company, but what you do for your back office or home office staff may be completely different than the policy you implement for your customer facing employees. And I think being able to think through what your needs are and maybe get a temperature check on what your employees are thinking, because like Chris mentioned in a big portion of his, there may be 15 to 20% of your employees that are not willing to get this thing. And if you're not willing to cut bait with all of them, just whoever it is, no matter what they do or how important they are to your company, then that mandatory policy may be real difficult for you to implement without raising a lot of discrimination concerns. So it's just really key right now to be thinking through all of this on at least a theoretical level, but trying to nail it down, because this is coming, and having a good answer for your employees and clear communication is key.
Hey, Chris, I didn't mean to jump in again, but I was on a webinar yesterday, and the number one thing that customers are looking for to get back into restaurants, whether it's home delivery or whether it's any type, is trust and safety. That's why this is so important, that I think our customers are going to say, is it safe to eat? Are those employees vaccinated? Or if they're not vaccinated, what are those precautions? Anything you would recommend that you would to help our members educate their customers on what they're doing? I think you did a little bit of that.
Yeah, I mean, I think, like I said, we've studied up on this, and I think in the industry there will be some marketing pushes. How that rolls out will kind of be company to company and an industry-based question. But I think being able to understand both right now where your employees' heads are, whether or not this is something they want to do, will set you up for knowing how quickly you think you'll be able to get this done. And I agree. I think Chris Bentley mentioned not too long ago, you can only control your staff. You can't control even if your staff's 100% vaccinated, half your customer base might not be. It may be a while before everybody really feels 100% comfortable. But I know even for me personally, if I knew a server in a restaurant was vaccinated and one wasn't, and I had my family with me, I may look for that. One restaurant, if you're picking between two restaurants and one restaurant has a vaccinated staff, that may influence a lot of people's decisions, especially in the next few months. So I think just thinking from a personal standpoint and just a rational standpoint, I know there's a huge interest in getting these people vaccinated so that you can make that claim, but we just want to be sure that you're thinking through, if it's not reasonable, what is reasonable, to make sure that you're not creating a lot of liability on the back end.
And Dan, and going off what you said, I had an interesting question just the other day about this, and is obviously we would like the employers, restaurants, and hotels to continue to do the safety precautions that we already know about. But the question came about was, if someone gets vaccinated, can they wear kind of like an insignia or something on their name tag or something that shows that he or she got vaccinated, right? And the problem is, the challenge is on its face, yeah, you can do that because you are not disclosing any medical information according to the guidance that's being issued by the EOC. The problem is that if you actually think through it, and because Chris and I were having a debate about this just yesterday, actually, and the debate is, if all of a sudden you're requiring or you're having employees wear this insignia, well, what happens about those ones that can't get vaccinated because of a disability? Before you know it, you're going to have more and more patrons or customers not select the individual, or not have the waiter, or not have someone serve them because of the vaccination. it could have a disparate impact on it, right? And all of a sudden you are not knowingly, but you are discriminating against maybe your disabled servers that are not vaccinated. There's been no guidance on this. It's just something that we could see maybe the plants bar eventually going to, should such a rollout be. So there's all these considerations, like what we're saying, is something that we would definitely need to talk through and discuss before implementing.
And because of this lack of guidance and how quickly everything's moving, that's why we keep saying, I think this has to be, is this conversation, a continued conversation you need to have with your council and with your company, because that sounds on its face, like you said, a great idea, but it has all these hidden landmines that you just have to think through.
Okay, thank you. Ashley, I think we got one or two questions you want to handle, please?
Yes, so one of the questions is, what liability falls on the company that requires the vaccine if an employee that did not want the vaccine and only took it to keep their job has severe side effects, which no one at this time really knows what those side effects are?
You want to go, Chris? You want me to do it?
Yeah, I was going to say, I think that would fall in the comp realm. If the person has no disability, no religion issue, if they just didn't want it, decided to get it because they wanted to keep their job and they had side effects, that's what we're talking about. There could be a comp risk there. There'd be no statutory protection, right? So when you run into legal problems is when the employer violates some sort of statute, and usually these statutes that we're talking about protect certain classes of individuals. Your dislike or distrust of the vaccine just based on your own knowledge is not a protected class, right? So that alone wouldn't be a problem, other than depending on how this goes with your comp carrier.
Great. And Dan, that was the only question that we've had come in. I didn't know if you wanted to close or allow for more questions.
I think so. I think the inauguration starts in about 5 or 6 minutes. I think some folks would like to watch it. I want to thank, also, if you have any other questions, please send those. Ashley, we'll send you kind of a recap of the recording right after this. If you have some questions you didn't get answered, we'd be glad to send them to us, and we'll send them to Chris and Chris. And I want to thank Chris.
And Dan, sorry to interrupt. And also, saying if you need to call us and talk through some issues, just go ahead and call us. Our number is down below. Please, we'll definitely be able to help you out or talk through some of these situations with you all.
And also, Carol Dover, our president, CEO, wanted to make sure we thank you guys personally for coming on today and appreciate your help. And you guys have been great partners. Thank you. Thank you, Ashley.
Thanks so much.
Thank you, everyone.
Thanks, Ashley.